I look back at this email string and my observations, I think that Steve Heinrich and Phil Jones are even that.
Well, let's talk about it.
It's 18 pages.
Well, oh, that email string, yeah.
Yes, I know, it goes through.
Oh. I did not print mine. I just scanned it last night. It was pretty well emblazoned in my memory. So the issue is, raised in his letter, highest value as reported in the inventory, any amended or supplemental inventory. And John, your point is, we tie it to a document so that there is a record of the value, because values fluctuate other than, between times. And this is a way for the court and the PR and everybody else to have a reference point for which value is being used.
Yeah, and I think what started this lengthy discussion.
Discussion.
Oh, what started it, as I recall, I couldn't read all 19 pages to get to the punchline. My recollection of what started it was a situation where somebody had inventoried a property at, say, $1 million.
Right.
And it turned out that that was overly ambitious, and they ended up happy to sell it for $500,000.
Right.
So $1 million was just blue sky, fine sky to begin with. It was really always just worth 500. And I think what Steve's writing about is that, well, if you have an inventory that shows $1 million, that's conclusive, and it's an outrageous fee.
Right. That's the gist of his point.
Which is a point well taken. I don't know what you do. Of course, not going to refund the filing fee. So I don't know what you do. I don't know how to fix it necessarily. His solution about is valuing every asset at the highest value during the probate is not a very good solution, because we rejected that when we were discussing this, because we thought, well, then, you could have a different valuation date, but we're going to get appraisal for every single day.
Well, yeah, and you made the point then that the PR is using a value that doesn't have any reference in the record for the purpose of calculating fee.
Yeah. So I don't know, what do you guys that see these things? Somebody submits a final account and asks for PR fee based upon $1 million value. The new statute isn't a deal. It's it's just sort of the old statute, the same thing. You got a $1 million inventory asset.
Is it property subject to probate or subject to the court's jurisdiction or something like that?
And the PR claims a 2% fee on that. And you look at the annual reports of the final account, and you see that, well, this $1 million asset was sold for $500. What do you do about the PR fee?
Shouldn't that be offset against the attorney's fee?
Yeah. Well, he makes a statement on the second page that I'm not quite sure I understand. Solution. Some lawyers have suggested the PR's lawyers should petition the court to award less than the fee calculated. I have clients take less than the fee, less than the. It's not required. The fee is not required. You can always take less than the fee. You can waive the fee entirely. So, I mean, but I guess that's not his point. I guess if there's bad faith, I don't know what you do about that.
Well, if there's an unsatisfied creditor, the creditor has an opportunity to object to the final accounting, which would go to that issue about couldn't they raise the PR fee? And I don't know what's the remedy for the heirs and devisees. Don't they get some sort of, they have to consent to a verified statement
or object to the final account.
Okay, so I mean that's
so an inventory would show that the asset was valued at $1 million. The accounting would show that it sold for $500, and the PR is calculating the fee based on the $1 million. The PR says, well, that was the highest value shown and or reported.
And
and my fee is statutory,
Yeah,
so.
yeah, so what's the objection?
Maybe that's true.
But I think when we talked about this before, because we did,
Yes,
one of the things that we discussed was when you look at the statute under subsection 2.
Yep.
We said the highest value reported in the inventory, any amended or supplemental inventory, any interim account or final account. Maybe we could just say that, because my impression was if you found out the value was wrong, you filed an amended inventory or a supplemental inventory, or you told the court in an accounting, look, the property is only ever worth $500,000. So I think that when we were talking about that, we discussed the fact that if you found out something wasn't worth what it was, you would have the ability to amend it. And I'm not sure how to word that in that statute, but that's my recollection of our conversation.
Well, and John, isn't that Mr. Heinrich's point that you have somebody who is not honest,
Mhm.
who isn't going to amend the inventory, who, says, woohoo, this is a windfall for me?
Yeah.
That's kind of what I read in his.
Yeah, that's what he's concerned about. Everybody knows that property was never really worth $1 million, but it was reported on the inventory at $1 million. And I don't agree with him, but I think he thinks that once it's reported, then that's an absolute fact. You can't change it.
right,
Well, the point where we've got bad faith guys saying this property's worth double,
yeah,
we have a breach of fiduciary duty for accurately reporting to the court the value of what's going on. We have perjury for lying in your inventory. I mean, I don't think the problem is calculating the PR fee at that point.
That's true on the bad guy, but that's not true on the
So,
later
I mean-
discovered facts. Right.
yeah, but
Well,
there
it doesn't
was,
have to be a bad person.
Right, the good faith.
I mean, I've had this happen. You report, you think property's worth $1 million. And then you find out after the fact that the previous owners used it in lots of ways.
right,
And you got a big environmental problem, and you're lucky to get 300. So, everybody's disappointed, but the $1 million was a good faith estimate. You just didn't know the situation when you found out the 300 was really the value. So, how do you adjust for that? I don't think the changes we made to the statute caused problems.
they might have highlighted the problem.
Yeah.
I think that's the thing, we were more explicit than the statute had been, and so it surfaced the problem that I think always did exist.
Maybe we should,
In the eyes of the court, because we did bring it up in earlier discussions, that it was hard for us to determine when was the appropriate time to value this thing
Yeah.
for the PR fee.
Yeah.
And we just made it clear.
Well,
And I
but
think we
doesn't,
struggled with this a bit.
you think the statute may address this?
You think so?
Because in subsection 2, at the very end, it talks about those various court documents that can be the basis. And it says, it may be based upon the evaluation of the asset to reflect its current fair market value. We can tie it to the current fair market value of any of those documents. But if they have erroneously stated fair market value, either intentionally or unintentionally, and that's all the problem, isn't it?
Two doesn't, because to reflect its then current market value.
Right.
The value on the date of valuation, which means the earlier value is wrong. It could have been a share stock that lost 50% of its value.
Stock is maybe the better example because it can fluctuate. If
Yeah.
it's a sizable amount of stock,
Yeah.
a small change will
Yeah.
make big ramifications.
Right,
I read it too as more saying, the PR fee is going to be calculated based on the highest value in any of those documents. So if you had stock that was worth $1 million at the start of the administration, it was worth $1 million. There was no error, but stock value declined
Yeah.
before you liquidated it. You had $1 million stake.
That happened yesterday.
yeah, right.
I think it's the later discovered facts.
Or the just the error, the mistaken value.
Or Christopher said, good, bad faith.
Yeah.
What about if we require that it be the highest value for which there was a good faith basis? And
But you can still have good faith basis when you figure out the tax based on. And so maybe it's not good faith, but it's accurate, because you can go back in time and realize, no, that was just way off. We thought it was a good faith estimate, way off.
I don't know that the toxic waste dump's a good example, frankly.
Why?
Because, well, I mean, you thought this property was going to be easy to sell, and now all of a sudden the PR is having to deal with, all the environmental hazard stuff. His workload has just gone like this. He's probably entitled to money anyway.
Oh, that's interesting.
Well, in 2008, we had all kinds of inventories filed on real property, and then it tanked. And, it went to nothing.
Yeah.
And
But on the date of the time of the filing of the inventory, if they had an appraisal or a comparative market analysis, that was an accurate number as of the date of the day for that asset. So that isn't our situation. Our situation is, they guessed wrong and the value's wrong, or whatever, the toxic waste. And at the moment that document is filed, it's an inaccurate value.
Right.
That's what is the accuracy of the time of the filing of the document.
And could we add, I'm just, conceptually, could we add a sentence to sub 2 to basically say that if an asset was
inaccurate.
If an asset was incorrectly reported, if the value of an asset was incorrectly reported in an inventory supplement, then
And the next highest value.
well, or
It's proper, or it's true fair market value.
then it's true highest fair market value.
You're gonna have
Well,
people
the
suing
thing
over
at
that?
that point
Yeah,
is,
they do anyway.
we're assuming you filed an inventory was wrong.
Right.
You learned inventory was wrong. You're not a bad person, so you file an amended inventory. And so it's the amended inventory number that's accurate and we should be basing it on. So I think falling back to the next document in that list works.
So can you just add to the words in the first line, valued at its accurate highest value?
Or was the highest value that was not in error?
Well, what about a material change between the highest value and the date of closing?
Well, that's different. As long as the value was accurately reported at the time, I think we're saying that it should be based, the fee should be based on that. You're incurring that risk and responsibility of an asset that did have that value. It really is either the mistaken or the change in facts situation. And I agree, if it's a breach of fiduciary duty, we're not going to fix it in this statute. If someone's going to lie to the court in an inventory, we've got other issues and ways to deal with that. But this is either a mistaken report or a mistaken valuation.
What does it say about the amended inventory? Does it say that you have to file one to correct? We have that somewhere. I just can't
You
remember.
have to file an amended inventory.
Because you can pick it up in the accounting.
Oh, okay.
Accounting.
Okay.
I think that's why we stated.
Yeah, that's right. That's why we included the accounting in there.
And that's 113.175. That's for any newly discovered property.
Right.
Not necessarily a change in the value.
Right. That would come through in the accounting.
I think kind of what you want is a reason that says, however, appropriate adjustments will be made to correct any valuation.
So, in this statute, not in the inventory statute.
In this statute.
Or you say the highest value for purposes of this section will not include valuations made in error.
We might need more around that because who's to
What?
say that the
That's what I
stock
was
market
just
crash
thinking.
isn't an error? You didn't, you should have predicted
You
that.
brought it on, oh my God.
That's why I like the later discovered facts issue, because later discovered fact isn't the change in the market.
Right.
Later discovered fact is
Well,
toxic waste.
It's that the error was as of the date that the document was filed and the value reported.
Hey, Lane?
Yes.
This is Ken Sherman.
Help us.
I have a kind of related question. If there's a piece of real property in the estate that's worth $1 million, and we assume that's a real value, and it's subject to a mortgage of $900,000, does the mortgage, is it clear from the statute that you take the mortgage into consideration in
don't.
determining how?
Yeah, you don't.
Excuse me?
You don't.
You do not?
Yeah.
Okay. And that's the way we want it to be?
Yeah, I think so. Because you're still managing the asset of that value with responsibility to the creditor in that case.
Okay. So that at least is not broken.
Right, that at least is not broken. And yeah,
Also, I think let's clarify for sure, if it's a good faith error.
right.
You know, later found that it's kind of, whatever it is it our intention that the highest amount, that $1 million, it should go to cover that from that, even if it ends up only selling for 500? Is that our goal, or we want it to get 500? What's the goal?
Well, that's a good question. I guess Mr. Heinrichs would be, it'd be 500,000.
But at the same time, we've bonded them and we've made them responsible for
Not
it
necessarily.
as an asset at the value they reported.
Not-
I'm not necessarily advocating that.
They never were responsible for $1 million asset.
Right.
Well, maybe the key is to tie it to the bond.
Yeah, you're not gonna have a bond in
Yeah.
so many cases.
This wording word, just add at the end of section 2, however, a reported value that is inaccurate at the time of filing shall not be used for purposes of this section. Because you're talking about each, as reported in.
Right.
In blah, blah, blah.
But then what value do you use?
Well, then you would use the next highest value. You're just not using that one. Then it's whatever the highest value is in one of the other documents.
Unless that was in error too. I mean, yeah, this is where you're chasing your tail.
We assume that it's the very end, at least your accounting value is accurate.
What's that?
You can screw up every single inventory, but the accounting value is either an accurate value or your accounting's not getting it.
But you've got a verified statement. You close it before a year is out and you've got a verified statement.
And everybody's agreed.
Yeah, that's true.
It's a stipulated value.
So they're all agreeing to the fee basically too then.
They are swearing to the accuracy of the number you report, so.
Well,
Yeah, but mistakes happen.
113.165 says the inventory shall show the estimates by the personal representative of the respective fair market values as of the date of death of the deceased of the properties described in the inventory. That doesn't expressly put a good faith estimate or level of certainty for those estimates.
So should we take the inventory out of that list? And it should be initial value as reported in first accounting or verified statement. Because we still have to go through and report an initial value there that should have been adjusted for any problems we found. And that's either your inventory value if you didn't screw up the inventory, or it's your corrected value if there was a problem with the inventory that you learned about.
Well, first, in response to that, they have to sign at all the inventory declaration that there's just true and accurate, the best of knowledge, whatever that wording is. So that isn't.
But mistakes happen.
But mistakes happen.
Yeah, mistakes
And
happen.
it's an estimate.
Yes, that's right, yeah.
It's an estimate. I've always wondered, what does an attorney ask their client about this estimate? You know, is it just, oh yeah, Dad already told me it was worth $1 million. Okay, there's our estimate. I don't know.
Yeah.
Well,
So,
and
yeah,
the other
that's-
part of it is if you have a verified statement, we aren't required to give the value of.
No, that's
all
right.
the assets.
That's right.
And so then that makes the inventory the value unless it's inaccurate.
But I'm not so concerned about the verified statement because everyone's agreeing to the amount of the fee at that point. So they've all accepted that and they think it's reasonable.
So they add the
Yeah.
file and.
Oh no, I want to fix. I don't want another problem.
So I've got this case right this minute. It's case of Ken's firm involved in. Fortunately, I was clever enough to use a living trust.
Yeah.
But if it had been a probate, here's what would have happened. I've got an interest in a family business. And the kids don't own this. And we're trying to negotiate a sale. If I had to file an inventory in probate, I would have put the biggest number I could justify on the inventory because I'm in deep settlement. They can always go down in the negotiations, but I can't go up. So I'd be an admission. So if I think it's worth $1 million, I'd probably put $2 million on the inventory. I'd negotiate a sale at $1 million, and I would report the value of the business interest on the estate tax return at $1 million and sold for. So I would do it that way every single time. So I would intentionally put the strongest possible value on the inventory because I don't want to give away my position. Then when I get to the end, it's ludicrous for me to claim a PR fee based on the $2 million number when I knew I was never going to get the $2 million. I actually sold the same asset.
That actually happens all the time in a simpler way, where you get comparative market analysis on residents.
Yep.
And the realtor gives you a range of value. And I always choose the highest value for two reasons. Number one, I don't want anybody to look at the public record and see what we think it's worth if there's some negotiation going on in the purchase. And number two, if I have $350,000 and that's a good faith estimate, and we end up getting 320, I want to take the capital loss and pass it out to my beneficiaries. So it's all about good faith. The statute is.
Yeah, there's a lot of room for strategy and still be within the good faith.
And the fix that Steve proposes is actually worse than the statute because it allows you to pick a value that nobody has any reference to.
Yeah, so his solution's not very good, but his thought is that instead you have to use the highest value.
Yeah.
He's thinking of the highest real value. So it's a fair comment, and I think the irrational change to add something that you calculated the fee after adjustments for valuation error or something.
Do we?
So here, again, just
Yeah.
code language. However, a reported value as adjusted in another court filing, that's some good wording, that is inaccurate at the time of filing shall not be used for purposes. I mean, those are the concepts I hear you're trying to address.
Right.
There's another court filing that comes up, and which could be an inventory, which is easy to do, or it could be verified statement. You stated in your verified statement the value of X was actually Y in the inventory. It's a one-line thing.
Could you use the word mistake
Well,
maybe?
how about something like this? If the highest value of an asset reported in an inventory, supplemental inventory, whatever, was materially overstated at the time of filing, then what?
The highest real value.
But we still want to peg it to another document, right? The highest.
Real value as reported in another filing.
How about if the highest reported value was materially overstated and the value is corrected in a later filing?
No, because if they don't correct it.
Yeah.
I like the start of that though. If the value of an asset was materially overstated.
You must file amended.
No, I don't want to do that because.
Again, isn't it gonna get fixed in the final accounting. If you sold an asset or liquidated an asset, or the other place that potentially overstating comes up is if you have a claim for personal injury or wrongful death, you're gonna choose an astronomical number to start out with because you're not gonna tell the defendant that you think your claim is only worth $200,000. And so they finally get liquidated at some point. If you've overstated it in an inventory, isn't your final accounting, doesn't it have to be accurate? I mean, doesn't it have to provide some other number? You can't repeat the overestimate in your final accounting.
Right.
So if materially overstated, you use the value in final accounting.
Didn't have to be true, but going through matching all the previous ones, when was it materially overstated?
Well,
First one later on in an amended.
well, it's if the highest value.
Yeah, so you look, but you have to, I guess I'm just, again, we're trying to be practical and make it as easy as possible.
Right.
So you're looking at the final, maybe just look at the final accounting. I mean, if you're saying it was accidentally materially overstated, and it was a reasonable material overstate, why not let them get that?
Well, but I still think we ought to, yeah, so maybe if it's material overstated, then the highest value for the purpose of calculating the fee will be the highest actual value?
Actual value on date of death? Or
No, actual value reported in an inventory supplemental amended or final account.
Well, I think it is.
Gretchen got-
Adjustments for errors. You got it.
Gretchen got me to think, we put in the statutes some methodology for a PR to ask for additional PR fees if they think they're entitled.
Right.
So why don't we just say, look, what the amount in the final accounting will be the statutory rate. If they think they're entitled to something more for some reason, they can ask for it.
Because we require them to say in the petition that they're planning to ask for more. And if they don't know that,
Yeah.
No, that's for the professional, that they have to do it in the petition,
Well, that's if they want to do an alternative version.
like an hourly rate. That's, yeah.
So come again, what was yours?
Well, I thought we had a provision in the statute that said a PR could ask for additional fees. Okay,
Right.
so if we just simply say, look, if you're gonna use the statutory rate, it's gonna be based upon what's in your final accounting. And then if you think you're entitled to more because of some reason involving the estate, you can ask for more as the PR.
Oh, I see.
Whereas, and those people who, if there's a verified statement, there's no issue. The PR has agreed to whatever he's going to get under the statutory rate. And if the PR thinks he's entitled to something more and files a final accounting, he files a motion asking for additional PR fees, explaining why he thinks he's entitled to more.
So the problem with that is a practical problem. It's the practical problem is in the final account, a lot of the assets are gone, either because they've been liquidated to pay creditors,
Right.
or you've had a partial distribution.
Right. Yeah.
So,
Well, because then your fee won't reflect any of those assets that were either distributed or cash that's been used to pay debts
Because they're no longer on.
because they're no longer on hand. Yeah. So it can't be. Yeah, oh, yeah.
This is kind of multi-year probate.
Right. Yeah.
Okay, so I have another idea.
Yeah.
If the highest recorded value of an asset was materially overstated at the time of filing, then the highest recorded value for purposes of this section for that asset shall be corrected in a later filing, including the final accounting or verified statement.
It's close.
So then.
Shall be corrected, though we don't want to put a requirement to correct an inventory in the accounting statute because it's too late.
That's what we say, in a later filing. So they could have corrected it in an amended inventory, or they could wait until the very end and in their verified statement say, in our inventory, we valued the real property at $1 million, it was really 500,000, and here's how we get to our PR fee.
Could you read that again, Jim?
If the highest reported value of an asset was materially overstated at the time of filing, then the highest reported value for purposes of this section for that asset shall be corrected in a later filing, including in the final accounting or verified statement.
I'm with you until the last couple parts. It's a good start. John?
If you look at the statute, filed under ORS 116.083, comma, if you insert after the comma, with adjustments for valuation errors. I think you got it.
Subject to adjustments.
Subject.
You want them to be,
I think you have to make the last part, though, which may be based upon, I think you have to make that a second sentence for it to make sense, otherwise it just goes on and on forever. So you change which to values, new sentence, capital V, values may be based upon revaluation.
Any interim account, file ORS 116.083, I would say subject to correction.
That, yeah.
but subject to makes it seem optional.
And it isn't mandatory.
Well, go back to with.
With correction, with any corrections.
Except as necessary to correct.
I mean, I would probably maybe put that in a new, you know, something. I mean, where are these corrections coming from? Is that a thing that exists right now? Can you, is there, if you file an amended something, correcting something, is it identified? I'm correcting the earlier value.
Well, what we made different, I'm confident, you know, the law before, just said it was based upon the value of the property that was in control of the PR.
Right.
So that was the
Under the jurisdiction of the court or something.
We tied it to the filings.
Right.
So instead of having to say, well, on, you know, a week from Tuesday, this was worth more, we tied it to the reported filings. That's a change that we made.
Yeah, I remember. Yeah.
And, you know, and the pushback here is, well, what if one of the reported filings is wrong? So we have to make the correction.
Well, I know. I guess what I'm saying is if you introduce this language about correction, what, you know, does the court know what that means? Does everybody know what that means?
It's not, a pleading is not necessarily identified as.
Yeah.
This is correcting what was.
Right.
Leave
How
it to
does-
the court to
I think
dig
it
through.
just.
How about like something like just say, how about just something like say,
Suggests a new file.
how about subject to adjustment in value for any assets that the value which may have been materially misstated at the time of filing.
Overstated.
Understood.
Materially overstated, yeah.
Well, I think misstated works better. You can't
Really?
screw it up in either
Oh, that's
direction.
true. Subject to, what's it, adjustment, I think so,
Of values.
of the value of any asset that may have been, that was materially misstated at the time of filing the inventory, whatever. Wow.
You could just say at the time of filing, because you referred to filing in that same paragraph.
You want to try and work with that?
Sure.
Well, I mean, it's conceptual. That's her job. You should see what legislators give her when they want a bill.
You're just adding more words to what I wrote.
Yes, we are. That's right.
It doesn't change anything.
No, well, it makes.
So I'm okay with it.
Yeah.
Just to humor you, but
So,
I'm just gonna say, you know, if you put yourself in the future, and the problem is going to present itself to someone. It's either gonna be a probate clerk, a judge, or a beneficiary. And they can say, wait a minute, you shouldn't be getting 2% on that million or whatever capital asset. And then when they look at the statute, they're gonna know exactly what this phrase means.
yeah.
So when we say subject to adjustment, we want to, that's the personal representative's adjustment.
No,
right?
it's adjusting the value.
I know, but this says to me like the court could come in and say your value is materially misstated. We're changing it for you.
But yeah,
That's what we want it to say,
That's what
so
we
that
want.
when the objection.
Yeah, we're
comes
talking about the
up,
value of the asset. Because once you get the value of the asset, the PR fee should be automatic from there.
Yeah.
You're not adjusting the fee, you're adjusting the asset, the value of an asset on which the fee is based.
But before it sounded like the PR was gonna come back and say, I made a mistake, I'm correcting it.
So we're leaving room for
Well,
either the PR.
Well, I think we are. This
Yeah.
this is passive.
Or for.
Okay,
Yeah, this is
somebody
passive.
to pop up, object, and make the court fix.
Yeah,
okay,
We don't need the PR to fix the error.
right.
okay.
We want the PR fixed.
No, we don't, because, the $1 million house was sold for 500,000, you reported the 500,000, now we're at the final account. And we don't wanna go back.
Right.
and Amend.
Right.
accountings.
You just,
So you don't wanna fix it, you want the error to be taken into account.
right, I agree, I
determining
understand.
what the
Yeah.
PR fee is.
Okay.
Right.
This is right.
Subject to adjustment of value of any asset that was materially misstated at the time of filing, something like that.
So where that number will be reflected in will be in a part of the calculation of the PR.
Yeah,
Okay.
Yeah.
And that's a court filing, it shows, okay, we made a mistake back whenever, and, okay.
and so if the PR, if it showed $1 million and the accounting shows that it sold for 250,000, but the PR still shows the asset in the calculations at $1 million, that opens the door for somebody to object.
And if they object, maybe they're wrong, because it sold for 200, and maybe they're right. I think it's.
Maybe it wasn't materially misstated, maybe the house burned down, but it was correct when it was filed. Yeah,
And that's a good response to the inquiry.
yeah. All right,
Burden of proof is always gonna be on the PR. When they have a question,
yeah.
you gotta tell me why.
Yeah, you gotta get your fee approved.
Well, okay, do you want to see if that language works or fix it? All right. All right, thank you, Steve Heinrich. We just spent 45 damn minutes relitigating issues we spent.
Somebody in here had some nice things to say about legislative council too along the way, so maybe I can.
Who said that?
Underline. I don't know, somewhere in here.
Who
there
said
was-
that?
Oh, in the string?
Yeah, in the string.
Oh.
I can't remember who
It's
it
probably
was.
one of the lunatics.
All right.
But this does address a big part of this.
Yeah, but I still say we didn't cause the problem last time. We highlighted an existing problem by being more explicit. So it wasn't something we did.
Right.
Okay, all right, let's go back.
It's amazing how seriously people take this stuff.
Oh, it is, yeah. Good for them and good for us for taking them seriously. Let's go back then. Marissa, what is different in yesterday's or Monday's version of 8888? Because here's my plan for the remainder of our time. To basically finish all the issues in LC 8888 today. Come back next time, we'll revisit wrongful death with the updated draft of wrongful death. And assuming we have time, get back into the virtual, the probate with the off ramps. And then we got to get to the form that Jennifer drafted and for the petition. Take a look at that probably sometime in November and hopefully put all the finishing touches in a meeting or two in December and be done.
That's what we have scheduled. We
Yeah.
currently have one more meeting scheduled October, one November,
Yep.
one December.
Yep, well, we may have one more meeting, but,
We can do that.
and we could always meet in January, I mean, because,
So we're also working on chapter 1 of that.
yeah, well, that's got to be folded in too. Just don't make it too big.
It's pretty much redone with extras.
Okay, all right, yeah, not a lot. Okay. We don't do well with a lot. So Marissa, what did you do?
Okay, so the changes.
Yes, what the heck did you do?
What did I do? What did I do?
What were you thinking?
The changes, I think, are in section 19, is where we were working. That is the only place I think I made any changes. Oh, hopefully it's still section 19. I think it should.
Then let's go to section 19 and see what Marissa has.
Let me see if I can see what I was supposed to change.
That's WROUG. Because I would like to get to the point where we can kind of walk through this and just do kind of like a punch list.
Does anybody see what I changed?
Well, we did change the part about the prison, so that.
Oh, the prison.
Yeah,
the
yeah,
prison.
yeah, that was easy.
that's an easy.
Uh-huh.
Okay, so, I combined 1 and 2 together.
In 19?
Yes, in 19. We used to have 2 parts, one that said you, may
Oh, yes,
distribute,
right.
and one that said you shall.
That's right,
distribute.
that's right.
And then, I added that you can't distribute until unsecured
Right.
creditors have been paid.
Okay,
That's what I did.
let's do section 19 then. If a petition to appoint a PR is not filed in 4 months, a small estate affidavit,
After the filing of the small estate affidavit.
I'm sorry, after the filing of a small estate affidavit, under 14, okay, after the completion of the 4-month period described, okay. After, this is a lot of afters.
Yeah, it's a long sentence.
After all unsecured creditors.
Yes,
have been
there's a
paid.
lot of little pieces to that now about when you can distribute.
Okay, let's walk through it again. If a petition has not been appointed within 4 months after the filing, okay, of the small estate. After the, how about upon the completion, just to get away from after, upon the completion of the 4-month period described in 540, and after, I don't know, is and wrong there?
Yeah.
After all unsecured, or how about if have been paid to the extent of the property estate and before the completion of the period, the affiant shall transfer the interest of the decedent in remaining property or proceeds described in the affidavit to persons entitled. Okay, what?
We just want to make the
Could we just say, if petition hasn't been filed, the affiant shall transfer when the following events have occurred, A, B, C, D.
Sure, we can try it that way.
Chris?
I was gonna ask the same thing.
Okay, so how would that go?
If petition to appoint a personal representative is not filed within 4 months after the filing of a small estate affidavit under that statute, comma, the affiant shall transfer the interest of the decedent in remaining property or proceeds to the persons.
This whole part goes.
Except, maybe you could say, shall transfer the interest of the decedent in the remaining property as provided in section whatever, if, and then we have the 4-month period has completed, the unsecured creditors have been paid to the extent of the property. And then we say, here's how that property gets transferred.
Okay, well, I can try to make this better tabulated, like that.
Okay, and I'm
That's
happy to let you
problem.
do that.
But,
So let's look at the concept.
The idea is
Yeah,
right,
see if the idea is right. So we're saying after 4 months, we want the affiant to distribute the property if basically all the unsecured creditors have been paid. Yeah.
Or you could even start it out by saying the affiant shall transfer if there's no PR appointed, the completion of the 4 months and the creditors do that. You could do that.
Lane, I do have one concern. It says before the completion of the 2-year, wait, hold on, I may have misread this.
It's
Well,
wordy.
hard with all the, yeah, that's
Well,
the way it's gotta be.
is there a reason we're referencing 2 separate 4-month periods?
They're the same period, aren't they?
Because if we're talking about the same 4 months, wouldn't it make sense to say?
Oh,
They aren't the same though.
After the completion of the 4-month period described in whatever, if no petition for a PR has been filed, all unsecured creditors have been paid, whatever are, actually, I think that was the 2 conditions there.
Yeah.
Rather than referencing the 4-month period in 2 chunks of the same sentence.
Are they 2 different?
So, yeah, I guess no, it's 4 months after the affidavit was filed.
yeah,
So
right.
those
So
should
it
be
is the same
combined.
4 months,
Okay,
yeah.
all right, that's good.
At least it's meant to be.
It is the same 4.
Okay,
So
combine
then,
these 2 4-month periods.
yeah, okay.
Point of confusion.
Point of confusion, yeah.
I'm dumbfounded.
Point of
by-
disorder.
I think you guys can straighten me out, but I'm confused by unsecured creditors of the estate have been paid to the property of the estate. What does that mean?
I made that up. I think I got it from somewhere else, but.
So if we run out of stuff. and
Right.
still have credit-
Then there's nothing to distribute.
But it's not maybe to distribute to the heirs and owners and WZs anyhow, so this,
Right, so you wouldn't need that.
So we don't need that?
they're not gonna be transferring anything to the other.
Yeah, to the extent of the property, the state can go.
Okay, good. We're making this less wordy.
Okay, yeah, that's
If
true.
you took that out, I would understand it, and wouldn't be confused anymore.
Okay, so let's take that out. Good.
Okay.
So what is the meaning, or how does the completion of the 2-year period fit in there? So is that at the start, after the 4 months, and before the 2-year period?
Yes.
That's how it was, yeah.
Do we need before the 2-year? Because we go to accept. Oh, and then we have the notwithstanding in B, there it is. Notwithstanding A, if there's a summary review, you don't distribute. So maybe we just say, except as provided in sub B.
I think you wanted it to say before the 2-year period because you want to put a affirmative requirement that the affiant actually complete those transfers. I mean, the normal course, the small state should
Yeah, you're
be
right.
fully complete within 2 years
Yeah.
because 2 years is the last point that anybody can
That's true.
bring
You're
up
right.
an issue about the administration. So they need to
Well, what
transferred any assets.
But
That's right.
But what good does that do us? Because if the affiant doesn't distribute it within the 2 years, there's no remedy. Because the 2 years is, I mean, you have to file your petition for summary review within the 2 years. So it seems kind of pointless to me. Or am I being,
So if all the other
you're saying
things
distribute it?
happen, if all the other things happen, creditors get paid in 6 months, then the affiant still has a 1.5 years before they have to leave the property.
Right. And if they don't deed it within the 2 years, nobody has a remedy.
Well, they do, because back in 550s, in section 17, it's 60 days after the period.
Yeah, we
So
took
they
care
have
of that.
60 days
We
to
took care of
file
that. We added we added time at the end for
Okay.
someone to force that. Yeah.
Okay.
Where was that, Jennifer?
That's in section 17, the new sub.
Yeah. Yes, that's it. That's it. Right, there it
After the
is.
completion of the 2-year period.
What's that?
So, in B, it's after the 2-year period, you can, 60 days, you can ask for.
You can compel
Yeah.
distribution, yeah.
And I'm wondering if in section 19, to avoid the affiant who's still living in the house from skating, because in between the 4 months and the 2 years plus 60 days, the affiant can stay there. In theory, that's a breach, but remember, these are simplified proceedings.
Is there any reason that heirs or WZs or creditors can't?
Yeah, they could file a summary review then. Yeah. They don't have to wait for the 2 years.
I mean,
Well, but the affiant can wait the 2 years the way this is written.
Yeah.
Okay.
File a summary review and
There's
statute
no
of laws.
affirmative duty to act before the end. of the
Yeah,
2 years.
okay.
Where's the 60 days come from, Jennifer?
It's
That's in
under
section 17,
Sub B,
new sub 1B. Is it 1 sub B?
yeah.
Which is good. We want that. Okay, so,
So I have another question, which is a concern that I have in this whole small state proceeding.
oh no.
Well, I mean, we talk about creditors, we don't talk about taxes. And are we counting taxes as creditors? Because the whole probate statute, you know, in the verified statement and final accounting, you have to say all taxes have been paid. And you know, people who are our audience, who are lay people, may not consider taxes to be debts or creditors.
I'm pretty sure if I tell DOR they're not a creditor, they're gonna.
Well, right,
They're not our
disagree
audience.
with me.
right. And we stated separately throughout the probate section. It's, you know, and even like priority of claimants, taxes, creditors, unsecured creditors. Taxes have higher priority than unsecured creditors. Yeah.
Okay, park that, because I still want to get this one figured out.
You're right.
I just, it's a concern I have.
So,
17 doesn't fix 19.
no, well, it doesn't. No, 17, no, what we want is to say that the PR, that the claiming successor has to distribute as soon, after 4 months, as soon as all these things happen. Yeah,
Yes.
That creates an affirmative duty, not the dawdle,
uh-huh,
and then you can,
as soon as practicable, or something like that.
yeah.
So, promptly.
Promptly, yes, shall promptly, yeah,
Ooh, I like that.
yeah.
That's, no, that's. a good
That's
one.
less syllables than practicable. Shall promptly, yeah, I mean, I agree, because we do want to put the onus on them and not give them the out to just sit on things for 2 years because they can't.
Okay.
So shall promptly, so read, now what do we have?
Okay.
Read it to us.
All right, if a petition to appoint a personal representative is not filed within 4 months after the filing of a small estate affidavit under ORS 114-515, after all unsecured creditors of the estate have been paid, and before the completion of the 2-year period established in ORS 114-515.
I don't think we need before now, if we're gonna say as soon as, shall promptly,
Oh, okay. All right.
we are
Oh my gosh.
just cutting and
We are.
slicing
All right,
here.
let's start again.
What you could say.
No, let her finish this now.
Okay, if a petition to appoint a personal representative is not filed within 4 months, after all unsecured creditors of the estate have been paid, the affiant shall promptly transfer the interest of the decedent in remaining property or proceeds of property described in the affidavit to the person or persons shown by the affidavit to be entitled to the property, and all other claims are barred except.
What do we think of that?
We like it.
Marissa says we like it. Yeah.
Here's what I would, because what you're talking about is you're giving the affiant a duty to transfer.
Yes, right.
And so I would say, the affiant shall transfer the interest as provided in whatever section. As soon after 4 months,
Well,
it has arisen and the following have occurred. As soon as, but promptly after 4 months and the following have occurred.
no, so you're just reordering it.
Yeah, because the point is, the affiant shall transfer promptly.
And then I think we even just say shall transfer promptly after A, 4-month period gone, B, creditors paid.
No PR.
Yeah, the
See.
problem is this except down here.
Yeah, yeah.
But
But
the
I
except,
can try to reorganize it.
Belongs in another sentence.
the except is about the, is not about the distribution or what
Because
is
that's talking about all other claims are barred.
Right,
So
that's, yeah, that's,
really, if we put a period at the end of or
All claims.
property,
all
and
claims are
then
barred upon distribution except,
Any other claims
I mean-
are barred except blah, blah, blah.
We could say except as provided in.
another section.
Yeah.
Well, one little
Whatever.
pesky detail about the 4 months. It's not just a matter of waiting 4 months. It's, if PR is appointed during that
Right.
4 months, then the affiant.
yes, right,
Right.
So
right.
that's part of our list. Oh, yeah.
I'm not offended by the current, there's somebody talking behind, in the background. I'm not offended by the order of the, if petition, although,
I have a slight conceptual modification to this. If 19 is going to be instructions to the affiant essentially about how to administer the estate, then what if it starts off with, if petition to appoint a personal representative not filed, blah, blah, then the affiant shall pay all allowed claims, because then we're telling them an affirmative obligation to pay those claims, and then transfer.
so we have
remaining assets.
the obligation to pay claims is already addressed under a separate statute. So I would just leave that to that statute.
Which one are you thinking of?
We have claims here,
Maybe it's not, okay, yeah, no, it is.
yeah,
Well, it's under 114.545, right?
yes,
It's there where they're saying that they have.
yeah, right, yep,
545.
yeah.
And then they have it.
Yeah, so I think that's okay. 19 assumes that that's been done. Because well, it doesn't assume because we're saying after the claims have been paid.
Claims and expenses.
We don't need under.
This is changing the
Under
kind of main point
I
of
think we've been
114.555.
saying it all over to cross-reference,
Really?
but I can. Maybe, because it's, we defined it up there, maybe we can take it out.
Yeah, we defined, right, small sale affidavit, yeah.
So as currently
You just want to
drafted,
take out all the
I think all
words,
this
huh?
statute is
Yeah, they're just
looking
going
to
to
do
Yeah,
is
yeah.
to identify the time at which the property is being distributed.
Right,
it kind of seems to me that might be better put into 114.545 because as currently drafted, the point of 114.555 is just to cut off new claims
well, it's,
and declare that the interest that invests in the heirs and devotees is subject to
right,
allowed claims.
so what's the issue?
I mean, if we want to direct the affiant to make certain transfers, should that go in 114.545 that describe the duties of person filing an affidavit? Because we worked a lot on that section to address their ability to transfer assets. You know, we talked about the yard sale and whether they could transfer with or without consent of all parties and so forth.
Yeah, except 545 is out of, it would be out of sequence there because we were adding section 15 before the completion of the 2-year period, about sales and transfers to third parties.
It's already in 545, because if you look at this on page 11, sub F,
Yeah,
it says from and to the extent of the property that, shall pay or reimburse any person who has paid expenses, claims is undisputed, allowed claims.
no, he's saying the obligation to distribute should be in 545.
Oh, I'm sorry,
But under 545 is a fiduciary under a general duty to administer, preserve, and settle and distribute estate in accordance with the terms of the will.
Yeah,
Expeditiously and with as little sacrifice as value is reasonable under the circumstances. So we've already gotten it.
generally, yeah,
So if you're sitting in the house, doesn't that give you, number one, you're a fiduciary, and number two, you're supposed to be doing it as expeditiously and with little sacrifice of value is reasonable under the circumstances?
that's the general statement, yeah.
So do we need to, if you're still sitting in the house and won't distribute the assets, isn't that where the heirs come in and complain? She's still sitting in the house, she won't give it to us.
But I mean, I still like 555 though, to create the specific obligation to transfer promptly.
It's got so much else in it.
Yes, it does, that's right, yeah, that's true. It'd be hard to fold all of it into 545. John?
So there's an inconsistency here. In 545, we talk about claims.
Right.
And disputed and undisputed. But then in section 19 of 555, we talk about creditors being paid.
Well, I thought that was separate from, or it's a smaller group, the unsecured creditors, right? Wasn't that the intent?
Yeah, because remember, because the mortgage is gonna pass with the property.
Well, we're talking about creditor, not a claim, and we're talking about payment. What if the claim is disputed? And the claim is, it's disputed and nothing happens. It's disputed, it goes to summary determination, and the claim's invalid. Now we come back to this concept of payment of creditors in 555, and I think it's consistent.
That was Matt's language.
Well, but except because no, I think we're okay there, John, because it says it goes on to accept as otherwise provided in this section and 114.540, which is the claim statute, and 545. So if you've got claims that are pending, that's an exception to the obligation to promptly distribute. If you've got disputes as to claims that are pending, then that is the exception. That is at the bottom of page 15. So we're saying you got to promptly distribute except as otherwise provided in this section, and we say subject to ORS 114, 540, 545, 550. That's claims, that's summary determination, summary review. So those things are going to delay distribution.
Well, still, but you can't distribute until the creditors are paid.
Well,
So what if your summary determination results in the creditor not being owed it? I gotta say, I just hate this statute.
yeah. So I guess you could say that
The whole thing and start over.
the allowed or undisputed claims of all unsecured creditors. That's how you would say it, I guess.
Say that again.
The allowed or undisputed claims of all unsecured creditors.
But how does that fit in? That's except.
No, that would go in the main body of the statute.
Where it says unsecured creditors.
Right.
In that first paragraph.
Oh,
Section 18,
allowed
or
or.
all allowed or undisputed.
Claims of unsecured creditors. So we're back to talking about claims. And the only reason we use unsecured, the only creditor is just that's how you talk about somebody who has a mortgage.
Or undisputed.
Do we need
Two different things.
Yeah, I don't know. Maybe you don't. Allowed?
I think
Okay.
allowed should be sufficient.
Okay.
Allowed claims of unsecured creditors. Well, so how does the elective share fit in?
Well, that's
That's in
sub
there.
B,
So then-
except.
So I mean, wouldn't that be, they'd have to pay that first? Before they distribute?
Well, that's at the top of page 16,
Right.
big B. That just says,
I think that the reason that the elective share is an exception is the timing. The way the current 114.555 says that if a PR is not appointed within 4 months, then the property vests in the
Right.
heirs and devotees, except as provided for disputes of claims and regarding an elective share. And I think that that's because the elective share can be raised at a point longer than 4 months.
Right.
And so you can't cut out the elective share opportunity.
right,
And that's why it's an exception.
So then it would be accurate to say that we don't want the applicant to distribute the estate if there are any disputed
Right.
claims. Or
Yeah.
if there is a potential elective share claim that hasn't, the time frame for that hasn't been passed.
So that's a problem that I'm seeing as we're going through this, is that before the property just automatically
Yes,
was
right,
transferred.
right.
Now we're saying that claims are barred at the time. I mean, I don't think this is what we want to say, but at the time the applicant transfers the interest, then the claims are barred. It's not automatic at the 4-month point, at the way it's written now. And I don't think that's what we want, but maybe I'm wrong.
Is Cleve still on the phone?
Cleve, are you on the phone? Calling Cleve.
Yes, I'm on the phone.
Okay, Heather has a question for you.
One of the reasons I'm curious about us changing this language is the current statute says the property vests in the
Right.
heirs or devotees. And so if we remove that vesting language and we alter it to a financial transfer, does that affect anything from the title company's perspective?
Well, the title has to vest at death, when the
Yeah.
title has to be vested somewhere at all times.
Yeah.
So I think we need to make sure that there's nothing inconsistent
Right.
between changes and the vesting in wherever it is.
Yeah, right, it does vest at death in the heirs.
Yeah, in 112, that vesting will remain the same for small estates as it does for ordinary.
Yeah,
Well, I may have confused confuse things because 114.555 does not actually use the word vest. I was using that as shorthand. It says all property described in the affidavit
is transferred, right?
Yeah.
Which is an odd form, and we're trying to make it,
Yeah.
so maybe, in order to make this explicit, work right, maybe what we need to say, in reordering is, if petition is, for a PR has not been filed in 4 months, all claims, and maybe we go to all claims are barred, except as, and the PR, and the affiant shall promptly, so we make the barring of claims automatic
I think that has to
at the end of 4 months.
Except as those other.
Yes, right, yeah, those
Yeah.
exceptions still play. So
And
I think we need to make that automatic and then say, and at that point, the affiant will distribute.
Having a one that is at this period, claims barred except A and B.
Right,
2, additionally, after that period and satisfaction of the below subs.
Right.
PR shall transfer,
uh-huh,
or affiant shall transfer.
yeah.
And then what do you want to, is that okay with that elective share part?
Yes, I
Do
think
they
that
need
is,
to
yeah,
reserve-
uh-huh.
I mean, if there's
Oh.
going to be a claim for that, do they need to think about that before they distribute everything?
What do
They
we,
don't now. I mean, essentially the remedy is the person seeking the elective share would claw it back.
Well, is that how that, I mean, it's, the statute doesn't, I guess when it says all the property is transferred to the person shown by the affidavit to be entitled. And then, yeah, and then if there is an elective share claim, then they have to try to.
So do they?
But we're
have 9 months
talking
in
about
elective share
pro se,
claim? Is that how long they have?
That's folks that have handed it out and people have already spent it the day that grandma died.
Same as a creditor, I face that all the time. We got a small estate that they either transferred on 4 months in one day or even before the 4 months. So they didn't know yet whether there was gonna be claims, but they transferred it all out to heirs and devotees, and then I filed a petition for summary review and asked the court to claw it back.
yeah,
You're not always gonna succeed, but
Yeah,
that's what we
yeah,
have
yeah.
under this setup.
So when you claw it back, do you get a judgment against both the affiant and the distributee, or who's your judgment?
Depends on the facts. If it was before 4 months, I think I have a good argument that I should be entitled to a judgment against the affiant because they shouldn't have distributed. Yeah, but if they held on to it long enough and then sent it out to heirs and devotees, then if they didn't do anything wrong, then I got a judgment against potentially multiple heirs and devotees, which, yeah, that's a headache. I had one.
Yeah, there,
Cleve?
well, another concern is if you claw it back, can you, does that undermine a transfer that the heirs may have made to a BFD?
Right.
So there does have to be BFD protection.
And my courtroom
Built in.
is full of pro se people that are all angry. I mean, I don't have an attorney in sight. And what am I supposed to be doing with this? That is kind of my concern
Yeah.
about saying shall promptly.
Okay,
Because we're talking to pro se people and everybody's just hotter than a firecracker, and I really don't have any good solutions.
Reasonably practical.
Well, I'm looking back at the language that we required, just as expeditiously and as reasonable under the circumstances, or something, as opposed to, you need to think about this before you distribute it to everybody. In my experience, I don't think in small estates, somebody sitting someplace is generally the problem. The heirs are all of them like a wet blanket, that they want their money.
Mhm.
Handing it out too early is usually the problem, at least in my experience.
Or they don't notify the other heirs and devotees. I see that a lot.
Well,
That's a whole nother issue, but yeah.
okay, let's get this, yeah. Well,
leaves me with all the pro ses.
But
We'll have a specific statute that.
we're still,
Well, if the judicial department wants this statute, that's what you're gonna have in your courtroom.
It is.
What's that,
Go
Jennifer?
ahead and retire, then you don't have it.
well, so I think we still are on the right track.
Yeah.
That no PR within the 4 months.
Right.
Claims are barred except these 2 claims. So
Right.
that part's good. So then the next part is about the transfer. And we're gonna say that they shall do that expeditiously, or whatever the word, after the allowed claims have been paid. But we have to restrict them from doing that before the elected share time runs. And we have to restrict them to doing that before the disputed claims are resolved.
Well, that's going to be the inverse of saying that all the allowed claims have been. No, because I mean it already says subject to 540, 545, 550. So that's all the claims process. I think that's okay. Or except as otherwise provided. So if there are disputed claims pending, this doesn't apply.
Right.
If there are disputed, it doesn't apply. That's already there. The issue is, the harder one is the elective share. Because the spouse has 9 months to file.
So then maybe you say, except as provided in section whatever, that is the elected share.
Well, how do you know if there's going to be elective share?
Well, I mean, that's the thing a lawyer would look for. Because they know under the will, the spouse was entitled to receive,
But this is curious. I mean, I know my practice. I mean, I'll distribute it after 4 months. I've never given thought to an elective share. I mean, and it's never been an issue.
it's a rare issue.
Yeah.
I have had cases where, because we're gonna talk about elective share, do we also need to talk about supported spouse and children? Because I've had the supported children issue on.
Don't you have to file a probate if you're going to do that? Because you're going to involve the court in an order.
Don't you have to file a probate for elective share? I mean, that's the same concept, isn't it?
But if
To
she
get
has
your
9
elective
months.
share maybe, but this is just, at least the way the statute exists now, your support claim is toast after 4 months. If you haven't made it, you haven't gotten a PR, or you haven't,
Right.
actually in the current statute, you haven't gotten a PR appointed, your support claim disappears.
Right. If you've got a
The
support
elective
claim, you've got
share
to
is
file.
the only thing that survives.
Right.
How do you make an elective share election? If you don't have it.
I think you probably have to, what?
You have to. 114.610.
Yeah.
A surviving spouse may claim the elective share only by
Right.
filing a petition for the appointment of PR.
Yeah.
But I have 9 months to file that petition.
Yeah.
Yes.
And
Susan,
the
why did you do that?
statute says elective share can be provided in those statutes. So unless you want to change the timeline.
One horribly unpopular option would be to stretch this to 9 months so that they line up.
Oh, that's terrible. Yeah, I mean, that's fixing, that's complicating 999 for the one.
So what happens, I'm curious, we have if you get a PR appointed, you file an elected share election with the PR.
Right.
There's no probate assets. How do you?
Well, you can't have a small estate and a probate at the same time.
Right.
You have to consolidate them.
No, let's say you give a PR 8 months later. Because you realize you got 1 more month left to go.
Yeah.
You get a PR appointed in the 8th month. The small estate, then it's all done, the property's distributed.
Well, and that's what we're, I mean.
So how do you go get that property?
Well, I think that's where Matt was saying, you file a petition for summary review
I suppose.
and try and go get the assets, because under summary review, you can. It allows the court to tell people to pay back, but yeah, that what are the practical issues there? And Lee mentions BFPs and things like that.
Well, and under the current statute, you can distribute regardless of the elective share.
Yes, you can.
The claims are barred, are barred except for that, but then you just say, okay, 4 months, you pay
Yeah.
unsecured creditors.
Yeah.
So that's something we have to address. Maybe that's a separate section.
What do you mean?
Well, so, I guess what it would be in a situation in which the decedent left a will.
You would have to say if the estate is subject to a,
Elective share.
yeah, claim for elective share.
Then the estate shall not be distributed until 9 months have passed.
Right, but will the affiant know that?
We're gonna say that in the statute.
Well,
A
can you
surprise
change
life.
it? Can you change the 9 months to 4 months?
Oh, but no.
Don't do that. You get a hold of another.
Yeah.
But it does say that you have to do it in the manner. I mean, what happens though is that this elective share does change timelines for small estates because it says the
Yes.
surviving spouse, they have to file a motion for
Right.
appointment of a PR,
Right.
and exercise their election, and that's obviously outside
Right.
4 months.
Right.
But the affiant should know that there's a surviving spouse. If you've got standing to file it,
Oh, yeah.
it's not like we're, trying to.
So can we
find-
say when the estate is subject to a claim for elective share and just signal to the affiants that if there are circumstances out there, then you need to wait 9 months?
Well, we're gonna have a statutory form. And so that would be in statutory form.
Ooh,
And you could also allow the surviving spouse to waive the 9 months maybe.
But see, if that's an issue, you really shouldn't even have a small estate. It should be transferred into a probate estate and address the issue. So the affiant should pull all the way back before they start, waltzing around distributing assets or doing anything.
Lane, this is Cleve. I'm
Yeah.
gonna have to sign off in
Okay,
about
Cleve.
2 minutes.
we'll try not to screw anything up too badly while you're gone.
All right,
Heather?
thanks.
Can I ask a tree question? So there was a discussion on the listserv this week that after the 4 months and no petition for probate, the PR can be appointed subsequently, but the PR doesn't have any authority under the assets of the small estate. That was the conversation on this.
That's right, yeah.
And so my question is this drafted appropriately so that if a petition is filed with the intent of the surviving spouse taking an elective share, does the new probate, after 4 months, have jurisdiction over the assets in the small estate?
Well, it does now because it says accept,
Okay,
so it specifically protects.
I mean, that's
Yeah.
the question, does that language?
Yeah, it does, I think, now.
So another thing we could do is just exempt the states where this issue could arise from the small state statute unless the spouse consents. That's a nightmare, but.
Yeah.
But that's
I
an
mean,
option.
that's probably a lot of them, right? Where the spouse is around.
Well,
or
but
unless
see,
they
in most
consent.
wills, the spouse gets all the property.
Right,
Yeah.
You
right.
know, in 99% of the wills, the spouse gets all the property. And
But-
so,
And the affiant is the spouse
right,
in a small estate.
Yeah, yeah.
You gotta
But it-
remember, the second marriage scenario where you got stepchildren.
right.
Because, you'll see dad dies, he's got a second marriage, dad's children, immediately run down to the courthouse and try to glom onto everything, so.
It's the opposite in my experience, that the surviving spouse doesn't think that the stepchildren have any rights.
Well, there's that scenario too.
Well, but that's outside of this. We're talking about we're talking about the spouse's claim. And the problem, I think, of saying you can't file if you might have an elective share is, you can't file a small estate if you have an elective share, is, elective share takes into account augmented estate, which are assets that the, affiant may not even know about at the time of filing. So I don't think we can just prohibit it if it's subject to. We have to take account of it at the end.
I truly have never had a problem, a practical problem.
No.
with the statute as it exists.
Yeah, right.
We're trying to fix something that's not broken.
Well, it's kind of like what we did with the PR statute. Are we making explicit a problem that at this point is kind of buried?
I want to dovetail off of Heather's point though, that maybe, and this comes back to what I said earlier, maybe 114.555 needs to remain like it is, and if we want to put a directive in there about when they're supposed to transfer assets, that goes somewhere else.
Well, we didn't like because is transferred. What does that mean? I mean, what does that mean? Is transferred? That's descriptive. It doesn't. That's.
Oh, maybe we take is transferred out of 555, put instructions for when to transfer into.
Well, we still have the same issue though.
545.
That's what Matt was saying.
555 is the.
Well, there was all this stuff below too about the liens and encumbrances. Maybe this came from someplace else, but I remember talking about this.
Oh yeah. Oh
I
yeah.
mean, we're not going to put all that into that.
No, not into 545. Right. No, I think we need to keep 555. maybe the best thing we can do is just.
Well, I mean, we could have the same thing happen, we had happen with Steve Heinrich's letter here, where.
Right. That's what I say. We're making explicit a problem that's kind of hidden right now in this weird language. If petitions, all claims are, so we start off in 1A, all claims are barred except as otherwise provided and for the purpose of surviving spouse's claim. Then we say subject to sub 1,
I was
know,
just going to say after 4 months.
Yeah.
It shall transfer its expeditiously.
yeah, right,
After allowed claims with unsecured creditors.
yeah. And we just, so do we say subject to sub 1 or sub A?
I don't think you need to. Oh, you mean because of the except?
Yeah.
Oh, yeah, okay. Well, I don't know yet, but we can do that now.
And then we're just calling out the elective share, but apart, unless we're just gonna say you can't distribute within 9 months, I don't know, we're not gonna fix it. And I don't wanna do that. No, I don't wanna do that. Well, let's just call it out. And first of all, it's not gonna be a lot of money because it's a small estate. And and none of us have ever encountered it as a real problem.
Okay, so just leave that. What do you mean call it out?
Well, I mean, so we say in 1A, if a petition for an appointed PR is not filed, we were talking about, all claims of the property are barred.
Oh, just like it is now.
Except A and B.
Yeah, okay.
And then in sub B, we say that, subject to 1A at the end of 4 months.
Yeah.
The affiant shall expeditiously distribute the assets, and that would be subject to the bit about secured creditors.
Okay.
And then, yeah. So does that work?
Does, because that makes the distribution and the transfer subject to the rights of the survivor.
It does.
spouse.
That's right. It does.
And
It just says,
which we don't
watch
even
out.
have right now.
That's what,
We don't even have that.
right. It's all buried.
Of course, any layperson, that's just gonna go right over there.
Right. It will.
And then they're gonna end up in the courtroom and everyone's gonna be mad and the money's gone, but that's what we have now.
That is what we have now.
Only it's a little less clear.
But now at least Judge Cobb will have something she can refer to and say
Well, and
what happened.
the statute says this was subject to this.
Right.
You didn't do this, affiant, and then you bounce back to you're a fiduciary,
Right.
blah, blah, blah.
So 1A is going to say if a petition to open a PR has not been filed in 4 months, all claims against the property are barred except A and B. Then we'll have a 1B, I guess, or a 2, whatever it's going to be, subject to 1A.
I don't know if I like the subject to 1A.
Okay, all right, I won't get wedded to it, but somehow we're gonna at the end of 4 months, the affiant shall, and after all allowed claims of unsecured creditors have been paid, the affiant shall expeditiously distribute the remaining property of the estate, or transfer the interest of the remaining property or proceeds of property.
Yeah.
Okay, that language? We try that? Okay?
Okay.
Then let's go on to two. Oh, no, say, what is now 1B, notwithstanding if the petition for survey has been filed, yes, then we have to leave that in. We can't distribute it until the summer review has been, are paid. And I think you can probably, oh, no, to the extent the property of the estate is probably appropriate there.
Can we rephrase that, because notwithstanding paragraph A, could we just say, if the petition for summary review has been filed under ORS 113.50, and subcommittee shall not apply the applying transfer of interest?
Well, then you appear to have.
No.
Yeah.
Yeah.
So, can you say despite?
No, I think notwithstanding is the language.
Notwithstanding is
But that, so that works. Then we go on to 2, property conveyed by an affiant is subject to liens and encumbrances against the decedent.
To the extent of the property is taken out there as well.
Do you think so?
I like it. I get it.
Well, it's still an exception to being able to transfer. So,
Well, I guess that's true if you've gotten rid of all the property of the state and there's nothing to distribute.
yeah, same thing there. If you take it out in A, it should come out in B.
I'm not sure.
I'm positive.
I think I agree with John.
Why did I?
Do you?
If,
Okay.
if you have a disputed claim, affiant can't transfer property of the decedent unless that claim has been paid, and if there wasn't enough to pay it, then there's nothing.
Then that's just dealt with in elsewhere. Okay, all right, fine. Property conveyed by an affiant under this section is subject to liens and encumbrances against the decedent or estate of the decedent. Property conveyed by an affiant under this section is subject to rights of creditors
Nothing
Un-
changed.
till the expiration of the 2-year period. That is true.
And that means that after you've
That's just restating what we've, more explicitly, what we've stated in previous.
We changed conveying to transfer.
What if,
Yeah, probably should be transferred.
what if a petition for summary review was filed and it hasn't been resolved yet and it goes past the 2 years?
That's the exception.
Okay, and
That's in B, notwithstanding paragraph. So we're going to say you do it after 4 months, but notwithstanding that, if there's a review that's been filed, you can't do the transfer until the claim is allowed and summer review proceeding are paid. So that puts the distribution on hold until the summer review proceeding has been resolved.
Well, this is about the property once it's gone into the hands of someone else.
Yes.
Yeah.
It too is, yeah.
Yeah.
So just so I'm clear, if you have a property, you haven't found a creditor, so you haven't noticed them, you wait the 4 months and then you distribute to the proper parties, that creditor
Yes.
who was never
Yes.
noticed has 2 years to come back.
Yes.
And so I think the lawyers need to understand that better. I just-
We can print that in bold.
No, I'm just thinking about
Yeah.
it as a practical matter because that's a real disincentive to using the small estate proceeding.
It's a risk. Yeah.
The claims period for creditors is 2 years instead of 4 months.
Do you tell the people that you give the property to? You might not want to spend all this money right away.
For 2 years. I mean, I'm just thinking,
No,
out loud.
We don't know.
Nobody tells them that.
no, no. That's just the way it is. That's the small estate.
Is this new language?
So,
But it's true.
I think it's.
I mean, but it's new language, but it is
4 month time doesn't cut off tonight.
not if they didn't get notice,
Yeah, but this statute seems to expand.
because you haven't published anything,
Well, let's say.
Yeah, you do.
huh?
You do publish.
Not in a small estate.
You file it.
You file it.
And you
Okay,
give
that's
notice
as
to
good
the
as
creditor.
No,
You don't give it.
You actually-
You
yep.
file it.
that's not notice to the world. I mean, that's not notice to creditors.
Well, and then you have to mail notice to
Yeah.
the disputed claim.
Where is
That
this?
you know
So
it.
you have so the 4 months doesn't cut off an unknown creditor.
No, and that's already the case in 555 because it already says the assets are transferred except as provided in 540, 545, 550. That's all in current law. So
it's unnoticed creditor has a due process.
Yeah.
Right to,
Yeah.
they can't be cut
The
off.
filing is not, well, it's not education.
No, huh?
I think though, we're unintentionally expanding it. And the reason why I would argue that as a creditor is, okay, I get notice that they aren't allowing my claim, and, do I still have 2 years to come in?
No, because it's all subject to those statutes.
Notice is the key. I gave you notice, you've got to step up to the plate.
Yeah.
It's when I'm not giving all those folks notice and just distributing it out that I run the risk of personal liability.
Right.
Or you don't know about the credit card debt because it's all done online and you don't have access to the decedent's computer passwords. And there's $2,000 in credit card debt that you don't know about, and then they track you down.
That's a risk you take in a small estate. We're not going to cut them off in 4 months just because. Yeah. What?
May I improve this a little bit?
Yeah.
Pointing out
You can try it.
there is no such thing as a lien or an encumbrance against a decedent.
Oh, the estate of the decedent. Yeah.
Or
Good
the
point.
estate of the decedent.
Yeah. Against the decedent.
Against the property.
There's
The
no
property
such
of the decedent.
thing. There are claims.
Well, you
There are
have
no liens or encumbrances.
you have liens or
Encumbrances are only against property.
right, and it's
So wouldn't it be
Nobody
that-
has ever in the history of the world had a lien or an encumbrance against other persons.
right. No, I get
So
that.
the
Property
of the-
conveyed.
They're indentured
Yeah,
servants.
property.
Property. Look at two. Property conveyed is subject to liens and encumbrances.
Should it just be on such property?
My point, it's the lien or the encumbrance is against the property.
Uh-huh.
It's not
Okay.
against the decedent or the
On the
estate.
property. Okay.
Okay. Yeah.
Would it be against the decedent's property?
No, against the property.
Just on the-
Property conveyed is subject to liens and encumbrances against the property.
Well, okay, hold on. It does need some reference, because we've already addressed this. Remember, we have a distinction between liens and encumbrances against the property based on the decedent versus based on the heirs or devotees. Because
Oh yeah.
a creditor of the devotee, a judgment creditor of devotee, doesn't then get to jump in line of unsecured creditors against the estate just because they have a lien against the devotee. So
This language is from 114.345, which is old. It's from 1969.
Okay.
So that one is property sold, mortgage, or leased by a personal representative subject to liens and encumbrances against the decedent or the estate of the decedent. It's exactly, that's the language.
It's been ludicrous forever.
Yeah.
I mean, I'm not saying it's great, but it's from somewhere else.
But I mean, it has the advantage of making it clear that we're talking about the estate,
Does
about the
Warren their
decedent.
estate credit writing?
It probably. Yeah. So we'll leave it.
This is a bit liability.
Sub 3, when an affiant transfers interest in real property, shall cause to be recorded in the deed records. Okay, bargain sale deed. When the affiant transfers interest in a manufactured structure, okay, you do it. Okay,
That was it.
yep, that was it. Okay, so let's go back to the beginning. Yeah.
But wait, did we address the issue of the property versus the decedent?
No, I think we said we're going to leave it because it's Warren's language.
Okay, so we'll just leave it the way it is, even though the decedent doesn't
Yeah.
have property or the estate.
It appears not to have caused anyone any problems
Can we
in
modernize
in
this provision?
39 years.
Can we just modernize this?
39 years?
It hasn't been around very long.
49. Since 1969?
Almost 50.
Yeah, oh yeah, 49 years. Yeah, it's been around 49 years. Hasn't been a problem. Has not been a problem.
Depends on who you ask about that. How many angry families are out there?
Okay, somebody needs to make it a problem for the next time this comes around.
John and I
Find a
do
lot.
it.
All right, we are going to do a speed reading fly through of.
Last time I did one of these, I regretted it.
Oh, I do them all the time. In the right case, they're easy.
Yeah.
Yeah.
For trust when you have a bank.
Yeah, exactly.
But when they're not like that, they're a disaster.
Yeah, you got to use your judgment. Okay, we're gonna go back and do we're gonna do a quick flyover. We are at 30,000 feet. Spotting issues. Okay. Section 1, we're defining small estate to mean, small estate affidavit means an affidavit or amended affidavit, 5.5, that's beautiful. Pardon? Oh, under 5.15?
Yeah.
Oh, okay, and then section 3, okay, person who meets the requirements, 5.5, may file a small estate affidavit, omitting under 5.5, only with regard to, not more than 75,000 fair market value, personal, 200,000 fair market value, real property, fair market value determined as of the date of death, or if the date of death is more than 1 year before the filing of the affidavit, as of a date within 45 days before the filing of the affidavit. Okay, we did that so that you can't wait 10 years and file a small estate affidavit on $1 million estate because it's appreciated in value. Right? You have to pick the value that's proximate to the time of filing. And, okay, yeah, Ken, this gets to yours, at least for the here, in determining fair market value. The fair market value of the interest in the property included shall be used without reduction for liens or other debts, or other debts.
Right.
Yep, so it's fair market value, okay. And the same rule applies in inventories in probate estates. So 5.15, down to 2, a person may not file a small estate affidavit if they would be disqualified from acting as a PR or they've been convicted of a felony. Small estate affidavit may not be filed, okay, so that's, okay. Let's go to 6A at the top of page 3, except as provided in section 7. The applicant shall file an amended small estate affidavit in the following circumstances: to correct a material error or omission in a previous affidavit, to include property not described in a previous affidavit. The amended affidavit, here's where conflating what were supplemental and amended, something like that. The amended affidavit must include all information required and state the value of the property as of the date used to prepare the original affidavit, right?
Now here's a reference to intermediate probate.
Okay, let's get there. If the fair market value of the property listed in the amended affidavit exceeds the limits, an affidavit may not file an amended small estate under subsection 6. The affidavit shall file notice with the court the estate is not subject to small estate proceeding, shall serve a copy of the notice on each person who received a copy of the previous affidavit. The applicant's authority with regard to the estate is terminated upon filing of the notice, except the applicant shall deliver assets to the estate and the applicant upon request to a personal representative appointed on 113.085, period.
Period.
Yeah.
So each person who received, that presumes that the applicant delivered the notice to who they were required to deliver it.
Right. Because if they didn't, that person, I guess, doesn't know, and they'll get notice when the probate's filed. The clerk may acknowledge an affidavit filed in this section upon presentation of identification. And so that was a court issue, Brian? That was so the people who come in and sign them in front of the clerk, is that it? Matt?
Back in 7, last clause, except that the applicant shall deliver.
Yeah?
It can take a little time between their filing that and the point when somebody gets appointed.
Yeah.
Should we include shall, retain possession of any assets that's come into their possession and deliver those assets to the person retained?
I don't know, isn't that sort of, isn't retained presumed with deliver? Because their authority is terminated. So they can't be distributing or paying bills.
Yeah.
Yeah, I think that's probably.
Because if they do anything else, then they can't deliver them to the.
Right, then they can't deliver, yeah.
I think with the audience we're writing this to, it would probably make sense to tell them that they need to preserve or safeguard the things that are currently in their care.
Well, is safeguard an exercise of authority? Because we're saying they don't have any authority.
Well, but they need to, so remember, some assets will come into their possession, some won't. Like real property, they may not possess it, that's fine. But if they've gotten the jewelry collection, they, yeah, they should, I mean, they, I think, I kind of agree with Chris that.
Well, can we just do with one word? So the terminated upon the filing, except the affiant shall retain and deliver assets of the estate?
Yeah.
Okay. I wouldn't go so far as protect, because that appears to impose an affirmative obligation that's inconsistent with no authority, but to retain, I think, is fine.
I mean, I guess, to me, this sounds like the personal representative can request that the affiant retain everything.
Oh.
Because the PR has martial assets.
I know.
see what you're saying. You see what you're saying.
So,
Because you could read it that way.
if there's no cash, does the PR have the duty to, I mean, does the claiming successor have the duty to keep the property insured?
No?
So we've got to be careful about.
At that point, you're a stranger, yeah.
Yeah.
No, I'm saying the personal representative, the duty shifts to the
Yeah,
personal
right.
representative. They have to marshal the assets, and they sit on their hands and expect the affiant, who now has no authority to do something.
All right, so you could say, is terminated upon filing, except that the affiant shall retain assets of the estate in the affiant's possession and deliver such assets or deliver the assets to the personal representative upon request.
All right.
Okay.
I'll make this
All right,
more
you caused
confusing.
that, yeah.
I read it.
So, yeah, we don't want them to have to,
I'm just gonna.
Affiant, you hold on to those while I'm busy. Okay, so section 5, no issue there. Section 6, no issue there. Section, why is this an unnumbered section?
Oh, because.
Well, that's the secret section.
Yeah,
5.5.
it's section 7, that's funny.
Section.
It's section 7.
Oh, yeah,
Does it go to 8 after that?
The
Yes.
next one is 8, so we're fine.
Yeah, right. So this
Oh,
is
I
the
know why.
requirements.
I know why, but yes.
And we're going to plug in a form here, but not, okay, so these are the substantive requirements of the contents of an affidavit.
Actually, read this. I know why this happened because this statute was changed in 2018. So when I went to do the doc compare, it stopped it. So I put it back in with the new one. So this is all, I just fixed it with the new language. So let's
You
read it.
understand that?
I'm-
You understand what you just said?
Oh, you don't know.
No.
The computer did stuff and took away the number. We put it back.
It wasn't intentional.
As long as you understand it, I'm
The
good.
language has changed from the last time you saw it because the language changed in 2018. So let's read it a little bit carefully.
Okay,
So I want a PowerPoint presentation on.
let's take a look at the substantive requirements because that's going to inform the form. Let's make sure we're happy with the substantive requirements of the small estate affidavit. And we're doing well.
So can
Um,
I ask a question about the word domicile?
What?
Well, so is the domicile, the where they lived at the time of death, is the domicile? state?
Domicile's domicile.
Well, I know, but I'm trying to
It's
divide that for these people, lay people in the form, and domicile, I translated into
Oh, no.
residence.
It's a defined term in
That's
one
what I
eleven
was
oh
wondering,
five.
yeah.
Means the place of the abode of a person where the person intends to remain and to which if absent, the person intends to return.
Right, yeah. So it's domicile. And look it up. That's what the form will just say. Look it up. Okay, date and place of death, the fair market value of all property in the estate, value is provided in subsection, or in section 3, which means without regard to debts or liens, including a real description of any real property. State that no PR has been appointed, there's no pending petition for appointment, and the estate is not currently being administered in Oregon. What?
Well, you can't administer an estate in Oregon unless there's a PR
Right.
appointed.
So is that redundant?
Yeah.
Seems redundant.
That there's no
Well,
pending,
no, this was after the petition's been approved. So there's no pending petition.
right?
And you haven't had an approved petition, so there's no estate currently being administered.
Oh, that's true. There's no pending petition and The estate is not, okay, that's
Although I
right.
guess now it also says no personal representative has been appointed.
Oh, yeah, and there is no pending petition. That's where you
Or
can
maybe
get
we
rid
just-
of,
Yeah, we
yeah,
get rid of something.
yeah. And that there is no pending petition. Yeah, okay, that's right. So Heather was right, because
There's
it's,
another small estate.
no, no. Uh,
No, I think that's a reasonable thing to put in there.
In
that
Polk County, there's a small estate, there's one in Marion County,
No
because
other,
I've seen that happen too.
All right, all right, all right. No other small estate has been, affidavit has been filed. Well, no, we'll do that. We'll do that.
No other small state petition has been filed.
Not a state, small state
Or
affidavit.
affidavit.
Yeah, and no other small state affidavit has been filed.
In order.
In Oregon, yeah,
of course, no other state has this process.
yeah.
Okay.
State whether the decedent died testate or intestate, list the heirs. Okay. And state that a copy of the affidavit showing the date of filing and a copy of the will be delivered to each heir.
hang on,
But,
going back to D, what we just added,
yes,
when we talk about forcing people to, when we do the amendeds, we make people come back and do all of the things we're talking about right now.
yes.
If I'm filing an amended small estate affidavit, by definition, another small estate affidavit.
No, it's this one. Yeah.
I think he's got you there.
No, he does not.
It goes in the
Again,
same
our
file.
audience is.
Yeah, no. And no other small estate affidavit has been, no, yeah, you do say no other small estate affidavit has been filed. No other small-
By another affiant.
Oh.
No,
If you think about it in terms of mitigation, if you file an amended petition, you don't have a new court case.
Right, right, yeah.
It's race
Yeah,
judicata.
that's what
You
you mean,
can't
that's
file your
what
amended petition.
Decedent, okay, testator and test list the heirs, and send a copy of the will if they have them. If the decedent died testate, list the devisees and send them a copy. State the interest of the property, describe the affidavit to which heir devizee is entitled, and the will as it was cheat. Reasonable efforts were made to ascertain creditors, list claims that are undisputed and that remain unpaid on account of which the affidavit, okay. Including the known or estimated amounts of the claims and the names and address, okay, creditors. Separately list the name and address of each person known to assert a claim the affiant disputes. And the amount of the claims disputed by the affiant. Okay, we're going to mail them a copy too. State the mailing address for the presentment of claims, and we can do the e-filing or e-notice. We can do that, just pick that up from our other bill. List the anticipated administrative expenses and attorney fees. State the affiant is not disqualified. State the copy of the affidavit showing and a copy of the death record mailed or delivered to Rick. State that the affiant's knowledge whether the decedent was incarcerated. We got that. Okay, you fixed this, right?
Mm-hmm.
In Oregon Correctional Facility in this state intended 15 years before they didn't consent. And if the decedent was incarcerated in a correctional facility at any time, state that a copy of the small affidavit showing the filing will be mailed or delivered to the Department of Corrections.
Wait a second, incarcerated in Oregon in a correctional facility in this state?
Right?
Do we need the in Oregon and the in this state?
No, probably not.
I'm gonna probably take the in this state out. It's the in Oregon,
Let's take that one.
clearer reference.
No, because they could be incarcerated in a county jail. And so I think,
Nobody said incarcerated in prison.
did we?
That's what.
Well, but
that was-
incarcerated in Oregon,
But-
not in the Oregon State Prison, just physically in Oregon is what that would mean to me, unless there's some kind of magical.
No, here's the problem. I guess if you just say incarcerated in Oregon, they might have spent 60 days in the Deschutes County Jail. They're not going to have to send notice to the Department of Corrections for that.
We need the correctional facility.
Yes, that's what I'm saying,
I'll take
yeah.
out in Oregon.
That's right. So we take out in Oregon, was incarcerated in a correctional facility in Oregon.
Yeah, work, yeah.
I thought we had, I mean, Department of Corrections, the reality is that they may have people that are incarcerated within the system and they have to send them to another state. From state,
Oh,
you know, so I thought that we had, I don't know why they're in the state, I thought the language I had didn't have.
Oh, you want it, any correctional facility anywhere?
Well,
No.
no. I still wanted to, it's just Department of Corrections that we're dealing with, but incarcerated, I
In a
can't
state correction
or-
facility.
In the custody of
Yeah,
the
I
Department of
don't- I have to
Corrections?
go back and look at what my language was, I'll try and find.
Okay,
Okay.
do that. I understand that, because they could be in DOC, but DOC, they're in Texas actually is where they're serving the time, but DOC is still paying for it.
Yes.
So you got the same issue. You got the
Yes.
issue. So we can't, the facility, it can't be the facility. It's got to be incarcerated under the jurisdiction or in the
Yes.
custody of, whatever that language would be, of the Department of Corrections.
Okay.
Okay.
So can I wait a year before I mail that?
What?
Can I wait 2 years before I mail the?
Oh. Yeah, I suppose you can.
Okay.
There you go. Yeah. But then you can't, but then you don't get your money until you're also just, but that, yeah, you can.
Don't you say within 30 days of 11 months?
Oh, wait, anytime within 15 before the date of the decedent's death.
They're gonna mail it, they just have to mail it anytime.
Yeah, so you wait
wanna-
2 years,
you wanna-
what?
Well, if you
Deadline
wait
on
1
that?
year to 11 months, you cut their claim period down to 30 days.
Fine. Still better than we got.
Within, are we putting a deadline in this?
No.
And one other thing I think we should clarify is, my understanding is this is only prison. This is not county
Yes,
jail.
right, it is only
Okay.
prison.
Yeah,
I think that is a correctional facility in this state. I
Right,
think that's.
exactly.
But we want to take out in this,
But we're gonna do-
it's really more under the jurisdiction of DOC, that's what we're talking
Yeah.
about.
To Heather and John's point, the obligation to mail isn't a separate, the timeline for the
Okay.
obligation to mail isn't a separate.
Let's, we'll come to that, we'll come to that.
Oh,
Yeah, that's in, is that 530? We'll come to it. State that undisputed claims will be paid as provided in 545. Claims against an not listed or in amounts larger than those in the affidavit may be barred unless a claim is presented within 4 months.
I found the language.
Okay.
I don't know if you want, what we had come up with, which was through DOC, looking at it and everything, state, whether the decedent was incarcerated by the Oregon Department of Corrections at any time within.
Okay,
15
there's the language.
years.
That's all we need. Incarcerated by the Department of Corrections.
Yeah, I'll just send that. to
Yeah.
you.
She's got it.
No, I mean, yeah, send it to me.
Okay. Sub 2, the affidavit shall file a certified copy of the death record as a confidential document. If the decedent died testate, the affidavit shall file simultaneously with the smallest of the affidavit, the original will, or if the original will is filed in an estate proceeding and there's a certified copy and a proof of the will meeting the requirements. Simultaneously.
That was something I think we were still thinking about.
We
It
were,
was
because-
from the UTCR, and then maybe, was there another?
Currently,
No, because with my experience, at least in Polk County, is you file the affidavit and a copy of the will electronically, you get a case number assigned, and then you attach a cover sheet to the will with that case number and you file the will. Is that what's supposed to happen? So you're not filing the original simultaneously.
Yeah, but you're a pro se person, you are.
Well, yeah, you may, but yeah, but I wouldn't, so you're saying within 7 days?
but that's a UTCR rule.
Yeah, well, but we don't want to make the statute inconsistent with the
The
UTCR.
technicality of filing the will is
Yeah.
actually when you're electronically filing. But you have to get the original
Yes.
to us. It's kind of an addendum. So whenever an original document is being filed, then that has to come in later and paid. So, because the electronic record is the.
Right.
Yeah.
So we don't want to say that they must file simultaneously.
So I think that's what
We just wanted to
simultaneously
capture the fact that they have to include the will with the electronic filing as well.
No, this is about the original. We've already said they have to attach a copy of the will, or attach the will. Yeah, that's,
I see.
yeah, we've already said that.
7 days is simultaneous.
It's in the UTCR here somewhere. I'm
Yeah,
looking.
didn't we take the word
Yeah.
simultaneous from?
The UTCR.
More better
We
that
did.
way.
More better?
Better.
Yeah, okay, maybe we did.
Irregardless, because the lawyers
Robin with
know.
Clackamas.
Yes?
The original will has to come in under UTCR 21, 7 days from the time of filing.
Should we just adopt that in the statute?
That would be consistent with the UTCR.
Yeah.
This pro se stuff.
But no, it's within, so they're gonna be fine. They can hand it over the counter at the same time. If they're at the counter,
They get a stamp.
well, that's right. They can hand it right over. They can. But we're just saying you don't have to do it that way so that you and I don't have to go to the counter and get the case number and then hand them the will at the same time.
So I
Well, we
found
say
it.
if it's electronically filed, it can be filed within 7 days. Because I think the court is not gonna wanna give a file number to any pro se person who doesn't have all 3 requirements, the original will with an affidavit, the death certificate, and the affidavit of successor. So I think that the 7 days is for people who are electronically filing, not for anyone else who walks in.
So the UTCR says,
Right.
oh, go ahead.
Was there somebody there on the phone? Nope, okay.
It was just Robin saying that that's correct. If they come in at the counter pro se, they have to bring it all in.
You could state that the affiant shall file the original will.
Yeah,
And rely
yeah,
on
the UTCR,
to tell you how to
good
do that.
solution. Yep. Yep.
Take out
Take
the
out
with,
simultaneously.
Take out the with the smallest.
Yeah.
Oh, shall file,
Or
just
shall
file.
also file the will, or a copy and proof of the will.
But there is a definition of, so UTCR 2173H1, if applicable, law requires an original document to be filed simultaneously with another document that is electronically filed.
Mhm.
Filer must electronically file an image of the original and then conventionally file the original within 7 business days after submitting the electronic filing.
I think
So
that's
we
what
picked
use.
simultaneously because it was defined in the process of the UTCR.
That's why I put that.
All right.
That's why I did.
All right, it's interesting. We are using a statutory term, we're using a term in the statute to link to a
Even though
UTCR.
the statute
Even-
overrides the UTCR.
Yeah, so simultaneously, I mean, that's the UTCR definition of simultaneously. Is it a statutory definition?
No, I mean, that's, no.
And I don't want to
so
define
if the
simultaneously.
UTCR changed, then,
Right.
you know, then
Right,
this wouldn't, that wouldn't change this. You still have to file it
simultaneously, and
Yeah.
then you'd revert to the dictionary definition of simultaneously.
Right. So, I mean,
Well,
If we
the
take that
statute
one
has to require that it was filed simultaneously for the UTCR.
Yes,
right.
but she's saying the UTCR changes, and I don't know what the. It's an odd, I'm just saying it's an odd thing for the statute to use a term because it's defined in a UTCR.
Right.
But I don't care.
It's not good with simultaneously because if we like toss out the whole e-filing system.
Right.
back to paper.
Yeah. All right. Actually, that works fine, because then you can file it and you get you stamp it in. Okay, we'll leave simultaneously. And, you know, Susan, that's a great comment. That's a great comment, that we are incorporating, we're referring to the definition of simultaneously in the UTCR. So, okay, that's not gonna be a problem for anybody, for electronic filings, yeah. Okay. Section 8, the affiant may deliver a certified copy of a small estate to any person who has possession of personal property or who was indebted to the decedent. Thank you, Ken Sherman. That means bank accounts. Except as provided upon receipt of the certified copy, the person shall pay the debt or transfer deliver property. Great, that's a good catch. 2, if a certified copy of a small estate affidavit was delivered, I think the rest of it is just to pick up that debt business, again, referring to accounts. And 5, the affiant may deliver a certified copy to transfer agent. Transfer agent shall change the registered ownership of the books of the corporation to the affiant or the person named in the affidavit entitled to it, corrected by the affiant. Here we go. This is where we say we're serious. If a person to whom a certified copy of a small estate affidavit was delivered refuses to pay a debt or deliver, transfer, etc., the affiant may file a motion to compel payment of the debt or delivery, transfer of, or access to the personal property. The court may award reasonable attorney fees to the prevailing party if the court finds the affiant filed the motion without an objectively reasonable basis, or the person refused to pay without an objectively reasonable basis. I like that. Yes.
So easily says.
Yeah, right. That's the end of 3 years, 4 years. Section 9, is there anything there that we care about? Oh, this is all about the inventory of the safe deposit box. Section 10, a claim against an estate with respect to which a small estate affidavit is filed, okay, may be presented to the affidavit within 4 months after the affidavit was filed. If an amended small estate affidavit is filed, claims against the estate may be presented within 4 months after the filing of the amended affidavit. And that again, that starts everybody over at 4 months, right? Because they may have seen that there was nothing there, well, I'm not gonna bother. Now there's assets, so you can't fake somebody out of filing a claim just by filing an artificially low small estate. Okay, so everyone starts over. Except as provided in 550, a claim presented after limitations described in A of the section is barred. Okay, filing a, what?
We talk about, we put the elective share and at least one other non-barred claim in 555.
Yeah, no, it's in 550. No, you're right, 555, yeah.
So do we need?
555.
I don't know, 555 is already already incorporated, that's kind of a two-way
Does
cross-reference.
550 include?
But it's fine, okay, fair enough, yeah. It avoids an ambiguity.
Is an elective share a claim?
I think they call it that. Was it a claim for an elected share in that statute?
A surviving spouse may claim the elective share.
But in the elective share statute,
That's the elective share statute. May claim an elective share only by filing a petition and a motion for the exercise of the election. So, yeah, do we need to do something there in 10?
And then,
No, because this is about claims. This isn't about elective share.
right. that's
Yeah,
what
we
I
deal with
mean,
elective share
that's
later.
where I'm-
Yeah.
so
This,
elective share is not a claim?
we're not for the purposes of this statute. I don't think so.
So then it's okay to, as read.
It's not.
It's not a
They're
claim.
not a creditor.
Right.
Okay.
No, that's right. You're claiming the elective share, but the
Well-
share is not a claim.
Yeah, and if they were gonna be a creditor, then you got issues with.
Notice. Yeah, right. Yeah, so this is just garden variety creditors.
But to be an elective share, you gotta be in probate.
Yes, you do.
You're bouncing this completely out of the
Yes,
statute.
that's right. Once you file the elective share, you're out of here. Right.
And we've already said in the.
Right, so you would never file an elective share in a small estate proceeding. Right. So that's right. So that's a null set. They don't apply, they don't exist in this statute.
Dave, I'm not sure I follow that.
What?
You're in probate, and you're not under this procedure if you file an elective share election. How does that happen?
Huh?
How does
You
that
have to have a personal representative appointed.
Right.
in
Right,
order
but how does that take away from the rights of the applicant?
Because we've already.
You
said-
have to file the petition to appoint a PR takes,
But it's not within 4 months.
yeah, we deal with that under five, just,
We said that they could distribute subject to.
right, and we're just gonna let them know that, watch out.
Right. So if they distribute, they're subject to the rights of the servant.
And then you got the issue where the PR those assets are gone, the PR is gonna have to try and marshal those back, recollect them. But that's not a claim, so let's stay with this. Filing a claim,
When we talk about claims that are not eradicated under 555, we also talk about claims in 545.
that is, well, those are proceedings.
Well, 545 is you have the duty to do these things.
Yeah.
Pay people.
Yeah. But this is what a claimant has to do. So I don't think-
Excessively limiting.
Yeah, this is what a claimant has to do, so I don't think 545 needs to be referred here.
As an experienced lawyer though, I'm confused by 114,541B. And the reason I'm confused.
541.
540.
Oh, 1B, okay.
The reason I'm confused is that it doesn't say that a claimant who is listed in the affidavit and who's received notice is barred. It says a claim presented after the limitations described in paragraph A of this subsection is barred.
Yes.
So my point there is if you don't get notice, and you're not listed in the
Well-
affidavit, and within 2 years you file a claim, somebody's gonna be arguing in this statute that you're barred.
Yes, and the
Relatedly-
creditor will then argue that that is unconstitutional.
Right.
Yeah, and so why would we write a statute that
It's always,
begins litigation?
Wait, where's 550?
Yeah, that's
Well, and
confusing to me too.
for
But
A,
everything is.
are we wanting to trigger off filing or are we wanting to trigger off notice
Okay, wait a second.
of the smallest
What-
affidavit? Because we're saying you, I mean, I know we say somewhere that you have to mail within a certain period. But here we're giving 4 months from the filing, so 4 months from the day I walk into a courthouse, regardless of when I, let Rick and Matt know that I owe them money, that I got dead people.
Well, you have a 30-day duty, you have a duty with 30 days to file.
So we're cutting their window to 3 months?
That's how it is now.
yeah, it's the way it is now, and as a practical matter, we often don't find, they don't send us the notice. And we find out about the small estate proceeding through alternative means.
So this says, except as provided in 114.550, that's the summary determination, which allows a creditor to file within 2 years. Oh, and then it says, a creditor may not file a petition under this section if the creditor received a copy of a small estate affidavit, and the creditor has not filed a petition for summary determination. Yeah, I mean, so I think 550 incorporates the exception for creditors who don't get notice.
No?
You can't file a petition for summary review.
Otherwise, I agree with Heather. I mean, we don't want to we don't want to enact an unconstitutional statute. We at least want to acknowledge.
If you got notice, you were shown as a disputed creditor in the affidavit. and you did not file a petition for summary.
Well,
But
Well, if you tell me how you want it to be, I can
yeah,
make it right.
so in
See, the problem is if you start getting into all this noticing requirement in a small estate, then you're basically starting to turn it into a regular probate. And so that's always been the balance.
Mhm.
And, I mean, do we want publication of notice for a small estate for $200? I mean, I think, while there is a Supreme Court decision, it's been a long time since I've read it, that says that there is some sort of due process rights for creditors, one has to wonder whether that's some sort of continuum or whether that's a bright line.
yeah,
I mean.
2 years is due process. You gotta-
Because the premise here would be, well, it's just not cost effective for us to make the small estate so much more complicated to give all these complex notices. I mean.
Well, what if we do this? What if we go back down to 550 and just make explicit in 550 that notwithstanding 114.540, a creditor who did not receive notice can file within 2 years.
That would be kind of similar to the way the regular.
Yeah, yeah. Let's just make that explicit in 550 so that except as provided in 550 acknowledges that a creditor who didn't get notice has 2 years to file summary determination and isn't barred. Okay.
Well, 1A of 550 already says that.
Well, that's what I thought, but nobody agreed.
Well, no, it
says
says
that
it's
you-
not barred if it's in 550. So if you add to 550 that the creditor who has received notice has the 2 years, then you're good.
Well, but 550 says the affiant and any claiming successor who has not been paid in full can come forward
That's
within 2
that includes
years.
creditor.
And so that includes your creditors.
Yeah.
And then it has a carve out saying that if you got appropriate notice,
Well, that's okay, that's
Then
where I
you're
was
not allowed.
going, yeah.
Well,
Yeah.
okay, but
So that makes the 4-month claims presented after 4 months being barred kind of like wrong.
Well, except as provided, so,
So it means nothing now because
Well,
550
that's
says any creditor is not paid in full last 2 years to come.
That's
No.
not true, John, because it creates an incentive for the affiant to make sure that creditors know. Because if you let a creditor know that you got the small estate going, they've got 4 months to get their claim in. But if you
and,
don't let them know.
yeah, and
550 allows a creditor to bring in.
Unless they
got notice, that's in 1C. The creditor may not file a petition if they received copy of the smallest affidavit or was mailed copy and has not filed, well, petition for summary determination.
So we should say in that statute that bars claims in a more affirmative manner that creditors listed in the affidavit, because that's all that applies to it.
Or who received, because you,
Listed in the affidavit and who received, it's both.
you're right, well,
This doesn't make any sense.
what?
So if you're a
So-
creditor,
You're a creditor, you can't, if you got the notice.
Right,
And you were shown as a disputed creditor, in the affidavit, okay, and you've
right,
not filed.
yeah,
I
that, yeah,
guess-
right, that's just in that particular.
This is weird, the way this is put together, I agree.
Okay, so let's, we're still at 30,000, we come down a little bit from 40. So, do you understand the issue?
Yeah.
Okay,
I still get it. What B says is unless you got a copy of the affidavit within 30 days of its filing and you were listed as disputed and
Right,
you
right.
didn't, give us a determination, you've got 2 years to bring the claim. And so the 4 months in B is ridiculous. There's nothing tied to 4 months anymore.
Well, if you got the notice
right,
and you were shown as a disputed creditor in the affidavit,
Right, then you got 30 days to act. And if you don't act within 30 days, then you're out.
right.
So you're barred at 30 days. It's still not a 4-month time.
Plus what, the 4 months runs from the date of the filing, right? Of the petition, so if you,
Maybe we just should lose sub B. It
Yeah.
seems to be creating more, because all these other issues are dealt with in the other
It adds
statutes.
nothing. It adds
Yeah. Why don't we just take B out?
That's why I was confused, because the truth is, I've had estates where I've hoped that 4-month period passes.
Yeah.
Because we can't find creditors because of the internet.
Mm.
And when you're a claiming successor, you don't have access to digital information. They don't give it to you.
Under, really under Rufata, I think you can. But anyway, yeah,
To make it work.
I
to
understand.
make it
Let's
work.
just take B out. I think B causes confusion, and
There is no 4
and it's dealt with in all the other statutes about claims.
The exceptions follows the rule.
Right, there you go. Okay, so filing a claim, so,
then we want to make a note to go back and fix something in 555 because we refer to the 4-month period in 540 and 555.
Yeah, I don't know what the 4-month time.
okay,
is.
all right, let's keep going, keep going.
We did talk about all claims are barred except whatever.
We'll get there, we'll get there.
Yeah.
Filing a claim doesn't constitute presentation, that all is language we dealt with before. Statement of reason for, yeah, that's all just incorporating the changes that we did before. Last interim. Okay, section 12. A creditor of the estate whose claim has been presented within the time permitted by 540, that still works?
that's a 4-month
Yes, that's 541A. Okay. A creditor whose claim has been presented within the time permitted and disallowed in whole or in part may within 30 days after date of mailing or delivery of notice of disallowance, file petition for summary determination. Okay? A creditor whose claim is listed in the small estate affidavit is disputed may within 4 months after the filing of the affidavit or amended affidavit listing the disputed claim, file a petition for summary determination of the creditor's claim by the court. So we got disallowed and we've got disputed.
Maybe that's why the 4 months is in there.
That's the 4 months.
What paragraph are we on?
12, section 12, 1A and 1B on page 10. So sub 1 is a creditor whose claim has been presented and disallowed, and B is a creditor whose claim is shown in the affidavit as disputed. May within the 4 months after the filing of the affidavit or amended affidavit listing the disputed claim, file with the probate court a petition for summary determination. Well, do we have to, or is that 4 months? I mean, that's,
Well, you want to say what happens at the end of the 4 months.
Well,
Because
let's
this is the summary determination procedure, so somewhere we need to say, apart from the summary determination procedure, if you don't do that, you're barred.
Well, and that's where we do say that, because that's the one in section 19, that we were working on earlier,
wait.
where we talk about barring, the claims of barred. Except for. Thing.
Yeah.
Yeah, that was at the end of the 4 months, the claims are barred.
Yeah.
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 Do we need to say that back in whatever we took it out of?
We did. Yeah, we do.
Section 10.
Okay.
It's coming back.
Yeah. Okay. Except maybe it.
Should we narrow it to say claims listed or whatever we talk about, what we talk about in A and B and 12? Those claims
Yeah.
are barred after 4 months.
Okay. We're making the punch list. This is on the punch list. We'll have to fix this. But we all conceptually agree on what we're going to do.
I can look at this too. I mean, I haven't gone through this.
You're
with all the
right. Yes.
cross-references
Right.
and
Right.
everything
Right.
yet, so.
So okay. So that's on the punch list.
So if I got this straight, the filing of the affidavit is not noticed to anyone.
No.
And,
Well, that's not true. It's noticed to us.
No. You got to get the filing is
I'm
not.
sorry, I'm sorry, my mistake.
so you gotta get, so it has to actually be given to a creditor. You can't distribute anything for 4 months because you have to have this magic time period for claims to be presented.
Right.
So if somebody happens to discover that you filed an affidavit and they present a claim out of the blue within the 4 months,
Yes.
then you have to deal with it.
Yeah.
If 4 months goes by and none of these creditors have miraculously discovered the existence of the affidavit, you can proceed to complete the administration, distribute all the assets, and then the creditors have to chase after the beneficiaries to get their money.
That's right.
So what seems to me to be kind of the question is, why do we, if you've got, you can't distribute for 4 months. But that doesn't mean you're going to distribute 4 months and 1 second later. So why would a claim presented after the 4 months, but before the assets have been distributed, not get dealt with in the administration?
Because there is a provision in the probate code that allows that, even if you're late, as long as you have filed your final accounting, you can still have to pay the claim.
There's a final accounting in it.
Right.
There's nothing, when does distribution occur in a small state? If I give out this to you on April 1st and I give out that to somebody else on August 1st, I mean, that's a difficult.
Well, but you got the affiant telling the creditor, look, I know you're owed money. It's been 4 months and 1 day. I know I have to give you a copy of the affidavit. You can just find out about it, and I know you got a claim, but it's too late. I'm going to distribute everything out to the beneficiaries, and you have to chase after them. I'm sorry.
Wouldn't that come under a breach of their fiduciary duty when they actually do it, and you could come after them personally?
I think that's a breach, not if the statute allows. Is it beyond standard of care? The statute
You
allows.
know a creditor, you have assets, you've acknowledged it's, you basically allowed the claim and said, too bad, I'm just gonna distribute
Doesn't
it
the
out.
statute require them to distribute?
But in our punch list fix, in our punch list, let's see.
It's kind of sharp to me. If you still got the assets, if you haven't distributed them, and you get a claim.
They have a duty, if they learn about a creditor before the 4 months, they have a duty to give back.
Yes.
Do they?
I
No,
believe
not
so.
under the current, no, there's no, I don't recall anything in the small state statutes that requires the affiant to do the due diligence for creditors.
Oh, that's in the affidavit. It's in
They have to say what they did to find creditors.
Does it?
Yeah, it's at the beginning. That's at the beginning. There's something.
Reasonable efforts have been made to ascertain the creditors
Right.
of the estate.
right.
So they didn't
But-
find somebody, and then somebody shows up, 4 months and a day later.
Or reasonable efforts were made at the time the affidavit was filed. Do they have to then amend the affidavit, have an affirmative obligation?
I don't see that.
I don't.
No, the
Well, they have to
amendments
present
only
their
as
claim,
to
right?
changes in the
Yeah.
But
assets.
his scenario is they presented a claim to the affiant,
Yeah.
and the affiant is basically saying, I'm gonna ignore it, I don't care.
Because it came in one day after the 4 months.
Oh, after the 4 months.
I made
Well,
a
I mean,
reasonable search at the beginning. I didn't,
Right.
I'm sorry. You showed up a day too late, so I'm gonna distribute everything out. And you're
Well,
gonna chase after.
I think that's the way a small state works though, because otherwise, we're not gonna be able to say that you can distribute after 4 months. Yeah, I think the creditor's remedy there is summary determination.
Well, but we also said you can't distribute the real property until all the creditors pay.
Which is where I think that the affiant runs a big risk of violating their fiduciary duty and becoming personally liable if they went ahead and distributed all the assets, and now there's nothing to, I mean, if you're representing the creditor, wouldn't you make that strong argument that they knew about me, they said yes, fine, and they distributed all this, and now it's gonna cost me all this money to get it?
Yeah. Well, no, I think fiduciary.
All right, we're gonna lay over in Chicago on this flyover. But we did, yeah, okay. So let's work on this between now and the end of the month.
Yeah.
I understand what the issue is. Okay, well, good. That's progress. Next time we'll do wrongful death, and I think we can get the form ready to look at by the end of the month.
are we,
Well, so we're gonna need a few changes to the form.
Yeah.
Right, right.
And I'm happy to work on that.
sure.
And you know that wording that you're doing with all that weird, I'm happy to look at that with you.
Okay.
Okay.
You want me to send this to you?